just a moment and make sure that we're all on the same page about our procedure here. Obviously, we've got experienced practitioners, and I know you're well acclimated to how things go, but I always feel better if we discuss it anyway. Each side gets 15 minutes to make its oral argument. If you're the appellant and you wish to reserve any rebuttal time, you may reserve up to 5 minutes of rebuttal time. And the proper procedure for doing that is after you've come to the podium and introduced yourself, you can request that from the court. Appellee gets no rebuttal time. We have a lighting apparatus on the podium. It has 3 lights, green, yellow, and red. Once you begin your argument, light turns green. As long as the light's green, you got plenty of time. Once the light turns yellow, it means you're running out of time. Once the light turns red, it means you're out of time, and we ask that you please respect those time constraints. One very important thing for the attorneys to be aware of, and that is all these arguments are being live streamed. That doesn't seem like such a big thing, except for the fact that once you say something, it's going out everywhere. So please be aware of that. We've had instances in the past where some things were said that perhaps shouldn't have been said, and the attorneys wished that perhaps they hadn't have been said. So just keep that in mind. Your panel today consists of Judge Karma McGee from Savannah, Judge Valerie Smith from Memphis, and I'm Steve Stafford from Dyersburg. Miss Ashley, anything we need to take up before we call the first case? You may call the first case, please.
Jennifer Hutcherson Hall et al. Versus Robertson County, Tennessee.
We'll hear from the appellant.
Good morning, Your Honors.
Good morning.
I'm Ken Berger from the Murfreesboro Bar. I represent the appellants in this matter. I'd like to reserve 5 minutes, if I may.
5 minutes, yes, sir.
This is a GTLA appeal, a claim based on the plaintiff's allegation that Robertson County failed to warn my client, Ms. Jennifer Hall, of a known and documented risk involving an aggressive dog. The case was dismissed on summary judgment by the trial court on a specific finding of no duty, and that was based on her determination that there were no disputed material facts in the record on the issue of the foreseeability of that risk. And before I talk briefly about the facts, I don't want to discuss the facts too much. Obviously, we've both presented all of the facts in our briefs, and I'll discuss those only to the extent I need to touch on these legal points I'd like to emphasize. But at the top of page 11 of the trial court opinion on that issue of the foreseeability of the risk.
Mr. Berger, let me ask you a question before you skip over the facts issue here. In looking at the issue that you have framed for appeal, your issue refers to, well, I'm just going to read your issue. In view of the controlling authority upon almost identical facts set forth in the case of Chase versus City of Memphis, was the trial court correct in its granting of the county's request for summary judgment dismissal of the GTLA claim? So I went back and looked at Chase versus City of Memphis because you say it's almost identical case and therefore it should be completely controlling. Well, in Chase versus City of Memphis, the dogs in question in that case, it was pit bull dogs. So I guess that's a similarity. I know this was a pit mix in this case, but those dogs, there were documented in the case and in the record, there were 5 documented attacks by those animals, the majority of which it looked like led to medical care having to be administered on an emergency basis. There were at least 2 other attempted aggressive attacks where the neighboring landowner filed complaints because he had apparently erected a fence, and the dogs had a 6-foot fence, and the dogs in question had tried to dig under the fence to reach his children on at least 2 occasions. So there were administrative hearings that occurred in Memphis through animal control to determine whether or not these dogs were vicious and or dangerous. So I'm having a hard time here saying we've got almost identical facts and that this is a completely controlling case when it looks like to me the only similarity is that there's a dog in both of them.
Well, I'll try to explain that as best I can, Your Honor. The difference is not in concept, but in degree, in the number of instances. Mr. Nolan raises what you just said in his brief, and my response to that is, yes, in the Chase case, there were 4 or 5 aggressive instances. In this instance, there was 1 documented aggressive incidents. It's like in a criminal matter. If you have someone who comes in and they've been charged with a crime now, and they say, well, this defendant was guilty of something several years ago, but he's not done anything in the meantime. That's sort of the defense in this, and the judge focused on that in the trial opinion. My point being, whether this dog was extremely aggressive and documented as extremely aggressive once, as is shown in the record page 228, Ms. Doris's affidavit, where she said, I couldn't get out. The dog was attacking me. So we had this.
Is that what she said? Did she say the dog was attacking me?
She says she could not leave her house because the dog would not let her due to its viciousness and its aggressiveness.
Well, you're kind of being a little bit loose with the language here, and I noticed that another time, I think, in your briefing, you refer to things that Ms. Doris allegedly said in her affidavit, such as you just did when you say she was attacking her. And I don't think that's what the affidavit says, and I'm sure that you're not intentionally misrepresenting that.
That's what I was about to say a moment ago. Judge Alita says at the top of that opinion, plaintiffs have not shown that the county had knowledge of Sweetie attacking or biting anyone. Well, I guess it depends on how you define attack. When
Well,
Ms.
you
Doris,
said, did you not just say that Ms. Doris said in her affidavit the dog was attacking her? Did you not use that word?
I did. What she described is that she could not leave her house because the dog was growling at her and would not let her get out. She called her neighbor, and the neighbor went over. The neighbor couldn't deal with the situation, so they called the animal control people. At that point, she's given the opportunity of filing a report on it. They take the animal into control, into the animal control custody, and she writes on there, aggressive dog. By my definition, I mean, respectfully, if I'm wrong, I apologize, but when she has a dog that she's so afraid of, she calls the neighbor because she can't leave her. This is not a matter as is characterized in the defendant's brief, or for that matter in the trial court's finding, that this dog was hanging around and was persistent and was refusing to leave. The dog was, by my definition, attacking her. Didn't bite her. She said it didn't bite her, but it would not let her leave her house due to its aggression, prompting her to write on the official report that the dog was aggressive. So, yes, I would characterize that as an attack. It didn't physically attack her, but it wouldn't let her leave her house, and it prompted her to say, I'm concerned enough about what we're dealing with here that I'd like for this animal to be taken into control, into animal control.
Didn't she explain what she meant later on?
I don't know that she did. She indicated that she was afraid, and that's why she labeled the dog as aggressive. And this is as subjective as can be. I mean, I'll concede that. It is subjective as can be. The threshold question on this appeal for us is we have the trial court finding that there was nothing in the record that could constitute an attack. Well, as far as physically attacking her, that's true. But when you have a citizen calling and saying, I can't get out to my car because of the way this dog is acting toward me. I'm afraid to go to my car because of the way this dog is acting toward me. I called my neighbor. My neighbor couldn't deal with it. We called animal control, and he had to use the pole in order to get the animal under control. So without, again, dwelling too much on the facts, yes, I believe the Chase facts. I believe, if anything, the facts in this case are stronger than the facts in Chase.
They're stronger in this case than in Chase, where the dog actually killed somebody.
Well, I'm not talking about injury. If we compared it on injury, of course that would be true. I'm talking about conceptually, was there a failure to warn of a documented known risk? And I say there definitely was. In Chase, in a mitigating way in Chase, they went through the appeal process, found there was nothing that really needed to be done other than the man who owned the dog needed to take the dog to dog obedience school, and they said to the plaintiff, Chase's relative, whoever that was, the poor lady who was killed with these dogs, effectively they said to her, we're going to require them to take this dog to obedience school. And if the dog is not taken to dogs are not taken to obedience school and dealt with appropriately, then we will take them into custody and either euthanize them or put them someplace where they can't hurt you. So in reliance on that, this poor lady walks out to her mailbox a month or so later, and she thinks that the dogs are still there. Apparently they've gone to obedience school. And that's paraphrasing, and subjective and paraphrasing, but I think that's a reasonable conclusion. The dogs were still there, so the lady walks out there and she's attacked and killed. So of course, in severity of injury, there's no comparison to these two matters. My client had her arms mauled and the ligaments torn, but thank God she wasn't killed. But as far as comparing the two cases, yes, ma'am. In that matter, there was a lapse by the animal control people in judgment, in not following up to make sure that he had gone to the obedience school. Lay that down side by side to the facts in this case. What do we have these people showing up, could have been a family with a 2-year-old, showing up to a place to get this dog, and they're told that the dog's okay, it's fine, has some kennel craziness and barking a lot, which wouldn't be unusual. They're told these things. They take the dog home, and my client is violently attacked, inexplicably and violently attacked, only to learn later that this Ms. Doris, who has nothing to, she's a disinterested, unbiased witness, said, I labeled the dog as aggression. I told why does the county have a process? Is it to protect the employees in the kennel? Or is it to protect a family who might have a 2-year-old or a 90-year-old, or Ms. Hall? What would it have hurt? You put this up on the scale of common sense. Risk versus benefit. What's the trouble in saying, you know what, Mr. and Ms. Hall? This dog was labeled as aggressive. You might want to take that into account. Why have the intake form? Why have the intake process and not give the poor, unknown, unknowable, innocent, prospective adopter the benefit of that knowledge? How much trouble? Why have the process? Why have the documentation that the dog is aggressive if you're not going to act on that by telling the person?
Is there contained in the record any observations or recordings of the animal control shelter during the 26-day period that the animal was there? Just a second. Is there anything in the record where they recorded or they made any type of notations as to the progress of the dog, the demeanor of the dog, the behavior of the dog, anything about the dog?
That's a big, none. The dog was fine at the shelter. The dog was fine when my client saw it. They deserved the benefit, that easy imparting of information that the county had that my client didn't have, that this dog had been aggressive to a woman to a point that she couldn't leave her house and go to her car.
Thank you.
Now, I call that an attack. Excuse me.
All right, we will hear the appellee.
Good morning, Your Honors.
Morning.
I'm Mark Nolan. I represent Robertson County, the appellee in this case. And I believe, essentially, that our position is that Judge Olita, the trial court, properly analyzed and granted the defendant's motion for summary judgment. And so to kind of come back to a point that counsel was just making, and he said, and obviously the court has Ms. Doris's affidavit, it speaks for itself, it says what it says. But he said it's a subjective opinion of hers. She saw the dog outside her house in the evening. She calls animal control, and they come out the very next morning. So there's a short observation window. Her perception was the dog is outside, and I'm afraid to go outside. It won't let me leave my house. She didn't go outside. There's no record that the dog attacked her. She does say her subjective opinion is it was aggressive. What we have, though, is when they get to animal control, had they brought that dog in that morning, counsel mentioned they had to use a catch pole. Well, that's what they use for all dogs, no matter what they're doing. They don't ever just pick up a dog. You're going to use the catch pole. But had they brought the dog in that morning and Mr. Hall had walked in an hour after they brought the dog in and said, I want that dog, and they're like, here, take the dog. Then you might have a better argument, because there was no investigation, no due diligence to talk about the propensity of the dog. But now we have objective findings over 26 days. You have affidavits in the record from the director. We observed the dog. The dog isn't biting us. It's not attacking. The director has a 5-year-old son that comes in, and they play with the dog. They bring the dog out of the kennel into the office to where the receptionist is, who describes herself as a woman of small stature, and she is not afraid of the dog. They don't have any incidents over 26 days. So there's no objective findings for the county to say this is a dog that should not be allowed to be put out for adoption. You have affidavits that say that it is.
Was there, or does the record reveal that there was ever any conversation between the Halls and the employees, the county employees, about the aggressiveness or how the dog came into be part of the shelter?
I don't know that Mr. Hall ever asked, how did you get the dog? He did come in, because there's testimony from his deposition, that he came in and he went back and he looked at the dogs in the area, and he had a pit bull before. He was interested in a pit bull, so it was not an unbred breed to him. And at first he came in and he said about that dog looks aggressive. That's his own observation, and the response is, the dog is kennel crazy, it's barking, it wants attention, which is not uncommon for dogs to do. And so then they get the dog out, and Mr. Hall has an opportunity to interact with the dog outside the cage, and that's when he's like, okay, I think this is the dog that I want. Because there was no biting or aggressiveness when Mr. Hall does that. So I think
as far as the history, though, the record's silent about that.
Correct. There's nothing in the record that during the 26 days while the dog was at animal control, there was any aggressive behavior. And the affidavits from 3 employees.
I'm probably not asking my question accurately enough. As far as Mr. Hall and him either asking questions about how the dog came into the kennel or the history of the dog, the record's silent about that?
Correct, Your Honor.
Okay.
I'm sorry, I misunderstood.
No, I didn't ask it clearly enough.
No, there's no record, and I don't believe that came up in his deposition. Did he inquire, or there was any comment about that? I'll say the dog had been picked up. I don't think, sometimes you have surrenders, but the dog had been picked up. In this case, Robertson County is a municipality. It's protected under the Tennessee Governmental Tort Liability Act. It doesn't have to do anything to get that immunity. It just has it. And that's what the cases say. And in this case, and I actually looked this up because I thought it was an interesting analogy, so I looked it up to make sure I actually had the right word. It is a Swiss cheese model of error. Now, a lot of times you see that when they investigate accidents, like with plane crashes. How did we get there? How did this system fail? How did that system fail? Things of that nature. So you have to have in a Swiss cheese a number of holes that have to line up before you have that type of injury. Here, the plaintiff kind of has the same thing. The plaintiff has to avoid multiple layers of defenses that are available to Robertson County. And any one would stop the claim from going. Here, Judge Olita said there's no foreseeability to the attack, therefore we have negated that element of negligence. We don't find the county responsible. The county also has as a defense, depending on what claim the plaintiff is traveling under, because they had made also claims of misrepresentation. TCA 292205 6 says that, because we're again looking at what does the immunity say, immunity is removed except for misrepresentation by an employee, whether or not such negligence whether or not it's such as negligent or intentional. Immunity is not removed for those claims.
Was there a specific claim made for misrepresentation?
In the plaintiff's complaint, yes.
And as best I recall, and I've slept since I've read the trial court's memorandum, the misrepresentation claim was not addressed in there, was it?
It is addressed as a footnote.
Okay, I missed that then. I'm sorry.
And it is on the bottom of page 9 of the order. It says, to the extent the plaintiffs have testified that employees of animal control made misrepresentations about Sweetie, whether intentional or negligent, Robertson County retains its immunity and the plaintiff's GTLA claim.
I actually had it highlighted, so there you go.
The point, and I think, and certainly this court knows, as long as there are things supported in the record, this court can enter its decision based upon any of it. Here, it originally was on the lack of foreseeability. The judge does also make a note of that footnote. So now we've got 2 layers of defense. What is another layer of defense? That is the public duty doctrine.
Was that ever addressed in the trial court?
It was not addressed by the trial court.
Okay, was it raised by the parties?
It was raised in the brief, and also the issue of the release. See, Mr. Hall, when he came to pick up the dog, he signs a release. And it says that he understands that Robertson County Animal Control and its representatives are not liable for any of the animal's health or habits.
So the trial court, I assumed that all these other issues were pretermitted, or these other defenses were pretermitted by the finding of foreseeability.
Yes, the opinion is 99.9% on foreseeability. There is the footnote about the GTLA.
Correct.
It does not address the others. The point being, this court can travel under anything that is supported by the record. We are not just limited by what the trial court did. So you have at least 4 defenses that the plaintiff has to defeat to have their claim go forward. And the record supports each of these defenses. And so it's proper that there is a summary judgment motion granted here like it was. In the court, I think, back to what they did grant it on, which was the foreseeability, the court understands and keys in, and I think that the importance of the observations that they have over 26 days, that the dog doesn't have any behaviors that should trigger a concern by animal control. It doesn't exhibit aggressive behavior in their presence. And to distinguish, which we did talk about just a minute ago, Chase, there was a documented long history in Memphis of this other dog biting multiple people. Not that it growled or not that it looked aggressive or it had its shackles. It had bitten multiple other people, and animal control knew that because they had intervened in other situations. So Chase, although a good case, I think is very distinguishable for this. I don't believe that it's controlling, other than to the extent you can see when you have those situations, they lost their ability to raise the defense because they never followed up. And it actually does talk about the public duty doctrine in Chase, because then they had actually taken an affirmative measure to say, homeowner, you will put up a fence. You will take your dogs to obedience. You basically will control your dogs, and then they didn't do it. And the city of Memphis didn't follow up, or Shelby County, I say the city of Memphis, Shelby County didn't follow up. They never said, we're going to send somebody out to see if you put up a fence. They never followed up to see, did you get a certificate that your dogs have completed obedience training? So they actually, and they gave the future plaintiff victim actually a copy of their orders of, here's all the things we've done to your neighbor to make sure that those dogs are controlled. and they just never followed up into anything. And that's why they didn't have immunities under the public duty doctrine available to them, because they had actually taken an affirmative step to protect a particular person. We don't have that here. So the case, although it does involve a dog, that's where the similarities end. I think it is important that the court looks at what were those affirmative things, those objective things. And in Chase, they had objective documentation that this dog bites people. And in this case, fortunately, Robertson County did not have any objective documentation, their own observations that this dog is aggressive. And even when you look at the affidavit of Ms. Dorse, again, which you have, it talks about she perceived, her perception was the behavior was aggressive. She never went out. The dog didn't chase her. The dog didn't bite her. When they ask her, did the dog bite anything, when she fills out the form, she says the dog didn't bite. So the information that comes to Robertson County is subjective, and then they take that and apply objective findings of their own observations over 26 days. They didn't know. You know, and obviously with a dog, we can't talk to a dog. Are you going to be good and get a response? So it is always going to be based upon observations. When you have observations over multiple employees over 26 days, and all those observations are, this is a good dog, we're comfortable letting him be around children, we're comfortable letting him be around the public in the office, don't have any problems, that's as good of evidence as you can have. No one from Robertson County knew or should have known it was not foreseeable, as Judge Aaliyah said, that this dog would attack Ms. Hall and bite her in the hand and the arm like she suffered. So it was appropriate for granting a motion summary judgment, and I request that the court sustain or affirm the dismissal.
Thank you.
Thank you.
On this issue of misrepresentation, no, we did not plead misrepresentation in the complaint. I know the defendant raised it in the answer, and it was discussed briefly at the summary judgment argument. We didn't plead it. That's an interesting point about that subsection of that statute. If there's ever been a case that discusses that subparagraph 6 about where the boundaries are for misrepresentation, I haven't found it. I don't believe my excellent advocate, opponent, Mr. Nolan's found it. I don't know what that case means, what that statute means. If it's a mile wide, maybe that covers us. There's been no case interpretation of it. But more importantly, the narrow important issue in this case is this. The instrumentality of Ms. Hall's injuries was the direct risk-informed control of the defendant, who, for reasons that are inexplicable in this record, that's the question. Why? It's not answered by the defendant. It's not answered by the trial court. Why don't you, if you're going to have a temperament intake form as a part of your operation, your operational policies, if you're going to have a risk-based temperament intake form, why do that if you're not going to do the easy, simple thing? There could have been a 2-year-old child in that house that would have been dead, like the plaintiff in Chase, if it had been somebody other than was able to fight it off. Those are matters of degree, not concept. This is a public policy consideration, an important public. What message needs to be sent to the animal control operations across the state of Tennessee? You know, we're going to have a process that gets the information as to why the dog is brought in here, and all we've got is this disinterested lady saying, I was afraid. I mean, her affidavit speaks for itself. When she says, I can't walk out on my porch and get to my car, if subjectively is that an attack? There's no objective definition of attack. I can't get to my car.
Do you agree that the record is silent on as to whether your client requested that information?
The record is not silent on the fact that they talked with him in 2 or 3 instances, and they said the dog is sweet and good. He said, I'm concerned.
Not the question I asked.
He did not specifically.
The question I asked was, did he ask anything about how the dog came into being at the kennel?
He did not ask for the history. He didn't ask for the history, but he did say the dog looks a little aggressive to me. He did say that. And they said, well, she's just cooped up and she's making a lot of noise and barking a lot. And he accepted that. They didn't. What would have been the problem with him saying, by the way, this intake form isn't just for the protection of the employees, it's protection of the prospective family that wants to adopt this dog.
But we don't know if he asked for it.
He didn't ask for the history, but he talked with them about the background. More pointed response to that, Your Honor, is that why would he need to ask for the history if they are saying to him, this dog is named Sweetie, not Cujo. This dog is Sweetie. It's been as sweet as can be, but it makes a lot of noise. He took that. He accepted it, knowing in this record that there was a piece of paper generated by them that said
Mr.
this
Berger,
dog is aggressive.
are you arguing that because of the dog's name, that the man should have known what the dog was like? I'm a little confused by that.
I'm arguing that that's consistent. They named the dog Sweetie while it was in there, consistent with their description to him that it had a sweet nature, which they did.
Well, I've heard a lot of people be called Sweetie, but it wasn't in a nice way.
Well, it could have been sarcasm, I suppose. Again,
Okay.
we didn't have a trial, so we don't know. Could have been sarcasm, but bottom line to what we say about this matter is that common sense set of scales, risk versus benefit. What would have been the downside to say, we've got a piece of paper here, Mr. and Mrs. Hall, that says that this lady couldn't get out to her car because she saw the dog as aggressive. He wouldn't have taken the dog. We wouldn't be here this instance. Her tendons wouldn't have been ripped open in her arms as a result of this dog coming into their home. It would have never come into their home. That is a classic, I respectfully insist, tort case of failure to warn of a known risk. They possessed the superior knowledge. They knew as a part of their job duties, and for reasons that absolutely do not appear anywhere in this record or in his brief, this inexplicable, we're going to keep it to ourselves. If that, from a public policy standpoint, that should not be the message to the animal control facilities in this state.
Thank you, counsel. We will take this matter under advisement. We will attempt to get you an opinion at the earliest possible time. You may be excused.